Well, thank you, Elizabeth, and thank you all for attending today's workshop. As Elizabeth said, I'm Damon Crane, Cohio's Housing Information Coordinator. So I'm responsible for operating Cohio's Housing Information Helpline and Rent Info email account, where we receive inquiries from tenants and unhoused folks all over the state and do our best to connect them with legal information and support services. Um, and prior to coming to Cohio, I was community organizer for about 25 years, the last 5 or 6 of which I spent with United Athens County Tenants, which is Southeast Ohio's only tenant-led tenant advocacy group. I helped found UAC back in 2020 and still volunteer with the organization in my free time. So today's workshop is really going to cover two things. One is going to be a basic introduction to sexual harassment prohibited by the Fair Housing Act. We're going to look at some common examples of tenant harassment and what landlord's legal liability is. We're going to look at reporting and enforcement. And then in part two of the workshop, we're going to do a case study looking at United Athens County Tenants' work on this subject. And then we'll hopefully have some more time for Q&A at the end. So to kick things off, um, sexual harassment is a type of sex-based housing discrimination prohibited by the Federal Fair Housing Act and state and local anti-discrimination laws. The Fair Housing Act is a major source of civil rights law and a major victory of the civil rights and Black Power movements of the 1950s and 60s. The Fair Housing Act is part of the Civil Rights Act of 1968, namely Title VIII of that act, which was passed by Congress under pressure from nationwide riots following Martin Luther King Jr.'s assassination. In response to other popular activism since 1968, the FHA has repeatedly been expanded to prohibit more types of discrimination. Something else that's important to note here is that some types of landlord sexual misconduct that are civil rights violations under the Fair Housing Act may also be criminal offenses under federal and/or state law. Today, we're really going to be focusing on the FHA protections and civil law, but I will note this a couple times that criminal law may also be at play. So some common examples of
So I don't know
landlord
where that
sexual
changeling came
harassment
from.
of tenants include such things as a landlord, property manager, or maintenance worker making unwanted sexual advances and or physical contact with a tenant, creating a hostile environment by entering the tenant's home at odd hours without proper advance notice, offering to waive rent, make repairs, or accept late payments in exchange for sexual favors, threatening or filing to evict a tenant in retaliation for the tenant refusing sexual contact. And again, while these are all violations of the Fair Housing Act, some may also be criminal offenses. For instance, unwanted sexual touching is usually defined in criminal law as the criminal offense sexual imposition. Coercing sex in lieu of rent can be sex trafficking. Of course, assault is a criminal offense as well. So those offenses can be reported to both civil and criminal law enforcement agencies. It's always recommended that folks who want to make a report contact a survivor advocacy group to help with that. Some important things to note there. Landlords are not only liable for violations that they personally commit, but also violations committed by anyone acting with the landlord's authorization, such as a property manager or maintenance worker, are two of the most common examples. Landlords may also be responsible for acting to stop violations committed against some of their tenants by other of their tenants. So that's something else to keep in mind. Um, Another important thing to note is that sexual harassment may or may not include physical contact. It can also take the form of unwelcome sexual advances, requests for sexual favors, offensive remarks, insults, or other hostile behavior because of a person's sex. So while it can include physical contact. It can also consist of oral, written, or other conduct that does not require physical contact. So if a tenant is experiencing sexual harassment, they can report offenses to multiple agencies, the first two of which are the Ohio Civil Rights Commission and HUD's Office of Fair Housing and Equal Opportunity. Now, both of those agencies share information and should collaborate in investigating any report. So, at least in theory, you report to one, you are effectively reporting to both. Doesn't hurt to report to both just to be sure. The main limitation with reporting to these agencies is that they will only investigate reports that have been filed within 1 year of the alleged offense. Now, a third agency doesn't have that limitation, and that's the U.S. Justice Department's Initiative on Sexual Harassment in Housing. There is no time limit on reporting. The DOJ will intervene when there's a long-standing pattern and practice of sexual harassment, usually situations where multiple tenants have reported the same landlord. Um, the initiative was launched in October of 2017. Since then, it has filed 48 separate lawsuits, I believe, to date, put dozens of sexual predator landlords out of business, and recovered about $17.5 million for survivors. Now, of those 48 lawsuits, on average, that's fewer than one per US state. But four of those lawsuits have been filed in just Ohio alone, and two in the single Ohio county of Athens County, which sets the stage for the case study we're going to look at today, which is how the local tenant advocacy group, United Athens County Tenants, has worked around this issue. And I think that, we can hopefully draw some lessons from this in how any local community-based tenant advocacy group can intervene and help hold alleged offenders accountable. So a little background on United Athens County Tenants, or UACT for short. UACT informs tenants of their legal rights and supportive services, counsels tenants experiencing landlord-tenant disputes, educates and empowers tenants as voters, advocates for stronger tenant protection policies, exposes bad actor landlords and holds them accountable, and organizes tenants to advance their collective interests. A few accomplishments over the last 6 years of its existence. UACT has created a website with tenants' rights information, webinars, and research reports. UACT succeeded in getting Athens County Municipal Court to pause evictions early in the pandemic before the national moratorium kicked in. UACT won pay-to-stay eviction protections for tenants in both the city of Athens and the village of Chansey. UACT also won source of income protections for Athens and Chansey tenants, helped win local anti-discrimination protections for queer tenants in Chansey, exposed negligent landlord Joe Kraus and forced his resignation from the Athens Zoning Board, forced the city of Athens to comply with public records law and release 17 years of code enforcement records, exposed the failures of Athens Code Enforcement and City Law Department to regulate rental housing according to the city's housing code, conducted and publicized local candidate questionnaires in 2 different election cycles, gained coverage in about 75 news articles so far, won a few awards, and beginning in 2021, UACT started trying to confront this issue of reported sexual harassment of tenants by landlords. And that's largely thanks to UACT co-founder Catherine King. And I'm going to run this video where she tells the story of how UACT's work in this area got started.
I was working in social services in Southeast Ohio, and I realized it was just this open secret that there were certain landlords that would sexually harass their tenants, typically in the form of asking for sexual favors in exchange for rent, or demanding sexual activity and threatening to evict people if they did not comply to those demands. The people that these landlords prey upon, they're really good at.
Oops, I think something just went wrong. Apologize for that.
Figuring out who they can target, who is least likely to try to put up any resistance to them because of all of their other structural vulnerabilities. So they would target young women, women without a lot of social connections or family support, women that were using drugs, women with young children, women living in extreme poverty, and assume that they would not be able to access the resources to try to bring these landlords to justice. And for the most part, they were right. Some, even case managers or therapists didn't know that this was illegal, that the solicitation itself was illegal, as people in the community tried their best to support these victims and get them help. It was just another thing on top of all the other things that these victims were navigating, trying to make sure that their medical card was up to date, trying to meet with all their different caseworkers, trying to get, maybe a charge settled in the municipal court. So it was like not on the top of the priority list. The reality is that people who are vulnerable are victims in so many ways of powerful people in communities in Southeast Ohio. And so I think that sometimes whether or not something's illegal almost is just a secondary question, because regardless of whether or not it's legal, it's kind of assumed that these powerful people can get away with things. So I think that kind of like structural everyday violence that people experience is just kind of taken for granted. I brought this to United Athens County Tenants as something that I was hearing about a lot. And we decided that we at least wanted to try to get the word out to people that this behavior was illegal and that there were possibilities for legal recourse. We created flyers that had information about the fact that sexual harassment by landlords is illegal, and what someone could do if they were experiencing that, both in terms of getting support for themselves, so like local resources for survivors, but then also in terms of legal resources if they wanted to pursue action against the landlord. I realized there were certain names, and the now well-known name of Joe Lucas would just come up over and over again with lots of different people from different organizations, different types of organizations. As you know, we know that this is a person that does this. So we put together mailers and then just sent those to every property that we could find that was owned by Joe Lucas. And we didn't say anything specific, about him, like we've heard things about him. But we just wanted that information to be out there to his tenants. Also, we did eviction outreach. So we would go to the local court website and find the names and addresses of everyone that was facing eviction. So we would either take them some information and talk to them, or mail them information about, again, legal resources to get representation in an eviction court. Here's some resources that might be able to help you pay your back rent so that you can avoid the eviction. And then we did add in this information about, if you've experienced this is sexual harassment. And again, these are your protections, and these are some resources that can help you. We also hosted a panel conversation with representatives from different organizations to talk about this issue and what it would look like if someone wanted to come forward.
Thank you all for coming tonight. My name is Lori Burgeshausen, and I'm a member of the United Athens County Tenants, or UACT. UACT is a countywide grassroots organization that works on housing advocacy, policy initiatives, and sharing educational information about tenants' legal rights.
So we had representatives from our local legal aid organization and representatives of domestic violence shelters and organizations that provided support for survivors of sexual abuse to just try to get this information out here.
Advocates from the Survivor Advocacy Outreach Program will be available throughout the event to speak confidentially one-on-one via the Zoom chat.
There were people I was talking to in the social services field who were mentioning things like this happening, and I was able to say, hey, like, you can come, or this person you're talking about can come to this event that we are providing that will give them more information about this, because it is illegal and people do have rights. So it was a resource that was obviously needed in the community at that time and that we were able to share with people. But in terms of numbers who came forward because of that, I have no idea. Those mailers were directing people towards the local legal aid organization or towards these survivor advocacy organizations. So we don't know who followed up. And part of it was also just starting that conversation, right? So even if someone themselves wasn't a victim, maybe in a couple of years, their neighbor mentioned something and they remember receiving this mailer. I was working.
And so that's where things stood in 2021. For the next 2 years, UACT kept including this reporting information in all of our eviction outreach packets that we sent to tenants who had upcoming eviction hearings. We kept the webinar on sexual harassment in housing on our website and saw that people continued to view it. But we didn't know what, if anything, was happening behind the scenes because, of course, any reports that people made were confidential, and any legal proceedings that might have been occurring were confidential. So we were kind of in the dark at that point until August of 2023 when this happened.
Department filed a lawsuit today against a landlord that owns property in Athens County. They claim he sexually harassed women that rent from him. His name is Joseph Lucas. He has owned and managed more than 70 residential rental properties in and around Athens County. The lawsuit alleges that since at least 2004, he requested sex acts from female tenants and applicants, subjected them to unwelcome sexual touching, made unwelcome sexual comments and advances to them and their female guests, repeatedly drove by and entered female tenants' homes without their permission, demanded that they engage in sex acts with him to not lose housing, and offered to reduce rent or excuse late or unpaid rent in exchange for sex acts. The lawsuit also alleges that he initiated evictions or threatened to evict the women who refused his sexual advances.
Now, note there the graphic that this news report includes says that the lawsuit alleges the behavior has been going on since 2014. That's a typo on their part. They did get it correct in the report that the anchor read, which is that the lawsuit alleges the behavior had been going on since at least 2004. So roughly 2 decades at the time the lawsuit was filed, at as many as 70 different properties. And so that really began the next phase of UACT's work on this issue. So if the first phase was about encouraging folks to report, encouraging illegal action, the second phase was to build upon that legal action once we learned the lawsuit had been filed. And to begin with, the announcement of the lawsuit, it received a lot of immediate media attention. I believe there were 13 different news reports just publicizing the filing of the lawsuit, the announcement by the Department of Justice. But after folks read that coverage, a big question that they had was which properties are involved. The news reports didn't say, and in fact, the government's complaint didn't say. It named the communities in which properties were located, but it didn't give any addresses. And UACT didn't have the list that we used to reach out to tenants in 2021 anymore. And when we went looking on the county auditor's website for records of properties owned by Joseph Lucas, we couldn't find any. So this became more of a problem because at the time we were lobbying Chansey Village Council to pass pay-to-stay eviction protections and to ban source of income discrimination. And one of our arguments was that the more housing choices low-income tenants have and the harder it is to evict them, the less vulnerable they are to sexual predator landlords. Again, as the news report mentioned, Joe Lucas was accused of threatening to evict tenants unless they performed sexual favors for him, and in at least one case, evicting a tenant because they didn't perform that sexual favor. So we knew Lucas had owned properties in the village of Chansey, but we didn't know which properties and we didn't know whether he still owned them. So it made it harder for us to connect this very prominent lawsuit to our policy advocacy work in the village of Chansey. We tried doing more research. We couldn't find any limited liability corporations associated with Lucas. So I started wondering whether ownership of the properties might have shifted to potentially family members with different last names. And I knew Ohio residents' online voting records often list the names of other individuals who voted from the same address. So I looked up Lucas's records, clicked on that voter details button there, and sure enough, I came up with the last name Bush. And searching the auditor's site for that name, combined with some other research, not only revealed 81 Lucas family properties, but also showed that in the year and a half leading up to the lawsuit, Lucas had transferred ownership of about $3 million worth of real estate assets at no charge, first to his daughter Candy Bush, and then to his grandchildren Jacob Bush and Joey Carr, and their spouses Jeremy Carr and Emily Bush. Now, obviously, one might suspect that that could have possibly been an attempt to shield those assets from any judgment or settlement agreement in the lawsuit. And also, by Googling the Bushes and Carrs some more, we learned that the Justice Department actually in February of 2024, about a month before we were doing this research, had amended its complaint in the Lucas lawsuit to add as co-defendants Jacob Bush, Joey Carr, Jeremy Carr, and then later they also added Emily Bush as a co-defendant. And the reason for that, the government claimed, was that Lucas had not only harassed tenants at certain properties that he owned directly, but he had also harassed tenants at properties owned by some of these other family members who had authorized Lucas to be their property manager. So this is also an example of landlords being liable not only for their own behavior, but also that of an authorized agent, such as a property manager. Now, all of this seemed very newsworthy to us, but whereas that the announcement of the initial lawsuit had attracted all this media attention, none of what I just mentioned had been covered at all by any media outlet. So, United Athens County tenants, we wrote up a report on everything we found. And in fact, I can let some B-roll go here that shows some of that. But we wrote up a report on everything we found. We included a spreadsheet of all of those 81 properties showing their values and how they changed hands among Lucas family members. We published that report on our website in June of 2024. and released it to local media. Media then linked to our materials in their coverage. They independently verified our spreadsheet. One outlet even created a map of all the properties. And included in that reporting was information on how additional tenants could come forward. And it just attracted more attention to the issue in general. And then immediately following the report's release, the Department of Justice reached out to United Athens County tenants, and then we had the opportunity to meet with their team in July of 2024. And during that meeting, we brainstormed with them how to come up with additional leads and encourage any additional survivors to come forward. Um, and the DOJ team also asked us if we knew of any other reported problem landlords like Joe Lucas. And in fact, we did. We told them about a landlord named Kevin Martin. Now, whereas, and something you might have noticed in some of the picture that we showed of Joe Lucas, he was posing with then State Representative Jay Edwards. Now, to be very clear, that photo was taken prior to the announcement of the Justice Department's lawsuit. But one thing that I think is important to note is that landlords in general are often involved in local and regional politics, sometimes state politics as well. Um, and we see them, making attempts to associate themselves with prominent politicians and office holders. So in the case of Lucas, he had that picture posing with Jay Edwards when he knew the Department of Justice was, when I say he, when Lucas knew the Department of Justice was investigating Lucas. And then after the lawsuit was announced, Lucas's daughter, Candy Bush, posted that photo all around social media as kind of a low-key flex there, trying to, I think, suggest her father had some powerful connections. Now, in the case of Kevin Martin, so Joe Lucas was a registered Republican. He's posing with Jay Edwards. Kevin Martin was an active member of the Athens County Democratic Party. He was a major individual donor to the Mayor of Athens 2019 campaign. And not only was he widely reported to have sexually abused his tenants, employees, and others, but he had twice faced criminal sexual assault charges, but on both occasions escaped conviction. So in 2004, he faced 3 charges of gross sexual imposition for reportedly subjecting a minor foreign exchange student to unwanted sexual advances and touching, but those charges were dropped after the alleged victim declined to return to the US to testify. Then in 2017, he was again charged with sexual imposition, but was permitted to bargain down the charge to a conviction of persistent disorderly conduct. Now, when we told the DOJ team what we knew about Kevin Martin, they thanked us for the information. What they didn't divulge and what we learned just a few weeks later was that they actually had already been working on a case against Martin. And in August of 2024, they announced, one, that they were filing the lawsuit, and at the same time announced that the lawsuit had been settled and an agreement had been reached. And that's typically how these things operate. They notify the landlord during the investigation. They enter into negotiations to see if the landlord is willing to settle. And if the landlord is not willing to settle, then they just announce the lawsuit publicly and it continues. So the lawsuit against Lucas and Lucas's co-defendants is ongoing, whereas this lawsuit and its settlement were both announced at the same time. I believe it was August 14th of 2024, or 15th, I guess, according to the document there. But typically the settlement agreements include two things. the landlord's agreement that they will no longer manage residential rental property, and that they will pay money to survivors. And so in Martin's case, he was ordered to pay about $170,000. Well, he agreed in the settlement to pay about $170,000 and was barred from managing residential rental properties. Kevin Martin actually then died of cancer 5 months later, this past January at the age of 72. While I certainly wish he had faced some accountability sooner, at least he was not able to escape it entirely. And I should mention one more thing about Martin. Um, whereas the government's complaint in the Lucas lawsuit alleged that Lucas had been sexually harassing tenants for at least 2 decades. In the complaint against Martin, the government claimed that Martin had been harassing tenants for at least 1 decade. Now, most likely, they were engaged in that behavior for a lot longer. But still, the reports that the Justice Department was working with in both cases demonstrated that these reports were occurring over a very significant period of time, 1 to 2 decades. Um, and so when the Justice Department announced the Martin lawsuit and settlement, it once more gave United Athens County tenants an opportunity to intervene in the issue publicly. So we issued a press release making sure that this was covered by local media. And then in interviews that we did with local media in that coverage, we once more connected the Martin and Lucas cases to our ongoing policy advocacy work for stronger local tenant protections. So, for instance, here's a snippet from one of those articles where they quoted me as saying these lawsuits underscore the need for elected officials in our county to pass and enforce stronger local tenant protections. Lucy Schwally, an attorney with LASCO, Legal Aid of Southeast and Central Ohio, was also interviewed saying that a public conversation about predatory landlords has long been overdue. The article talks about me connecting it to our policy work in Athens and Chansey. And we kind of ended on the note that, quote, UACT is always ready to not only hold accountable local politicians who do wrong by tenants, but to work in concert with local politicians who want to do right. And that was how, again, we connected this to our local policy advocacy work. And so to sort of give a recap of this whole case study of how United Athens County tenants engaged with this issue, it kind of had two different phases. The first phase was encouraging legal action, and that's what we did from 2021 to 2023. So we did that targeted outreach to tenants of one reported offender. We did more general outreach to all tenants who were facing eviction with our eviction outreach mailers. We also did more general outreach via that webinar that brought together tenant advocates, legal aid attorneys, survivor advocates, and that served a few different purposes. One, hopefully, folks who attended the webinar benefited from it, but we also still have it on our website to this day, so it continues to be a resource. And it attracted a lot of media attention both before and after the event. So it was also just a way, it was a media event in a way to increase UACT's visibility as an organization that was working on this issue. That made us more visible to survivors, let them know that we could help them report and connect them with reporting agencies. I should mention that we were usually directing folks to LASCO, Legal Aid of Southeast and Central Ohio. And they basically started building these lawsuits, is my understanding. And then they reached out to the Justice Department initiative. And So they really played a hugely important role there, LASCO. Um, and yeah, so that's what we did in that first phase. Then the second phase was building on that legal action from 2023 to the present. So that involved researching and publicizing unreported aspects and developments in the Lucas case. So we revealed the properties that were involved, that transfer of property ownership in the lead up to the lawsuit, the values of the properties that were at stake. And that helped alert tenants of those properties of the fact that they were living in Lucas-owned properties when they may not have been aware of that. Lucas family-owned properties when they may not have been aware of that. It drew renewed attention to the issue after the initial coverage we saw in 2023 had died down and after the coverage we got in 2021 around our work had died down. So it was just another way to keep the issue alive. And all of this reporting should have encouraged more survivors to come forward because thankfully all of the coverage that we got did publicize how folks could report. And then we connected landlord sexual misconduct to our ongoing local policy campaigns for stronger tenant protections. And we made that linkage in the news coverage that we attracted to the issue. We did a presentation for the city council of another Athens County municipality, the city of Nelsonville. And then we also addressed the issue in our candidate questionnaire in the contested city council primary races in the city of Athens earlier this year. So those were all ways that UACT as a local tenant-led tenant advocacy group was able to work in relation to this issue. Publicizing the existence of the problem, encouraging survivors to report, and then attracting additional attention once the lawsuits had been announced. And before we take some Q&As, I want to kind of give a last word on all of this back to my colleague, Catherine at UACT, and then we can open things up for questions.
We met with quite a few representatives from the Justice Department to talk about this issue when they were bringing these cases forward. I also told them how much it meant to a lot of people who had been working in this area for years and years, and how like emotional it was for us that we had watched these people that we cared about be victim to these horrible men over and over and over again, and it felt like there was nothing we could do about it, and nobody cared. And to see the Justice Department come and take up this case, and for them to get some sort of validation and some just some form of compensation was so moving, I think, and made it feel like there was a little push to change the power dynamics, that these people were being treated as worthy when it felt like our whole local system had just ignored them. As we, I think, have seen with what's been proceeding with some of these court cases, as some people come forward, it gives other people the kind of courage to step up as well. Kind of a piece of advice, if other tenant organizations are interested in taking this kind of approach, is to, if you don't have experience, try to read or take some trainings or something on victims of sexual harassment, and really just approach people with empathy and with a listening ear. I think that when we see a situation, there's part of us that just wants to be like, you have to follow through. You have to take this, landlord to court. You have to call an attorney. But there's so many reasons that people don't want to and aren't willing to. And honestly, unfortunately, sometimes that it's not in their best interest to, because sometimes people feel like my two options are to be homeless and to live in a house owned by a slumlord that's sexually harassing me. I'd rather have a home. So I think it's really important to let tenants take the lead on what they need and what they are willing to do, because any tenant organization, like, we don't have all the answers, we don't have all the resources, and people know how to survive, and we have to respect the tactics that they know of to survive and just try to offer as much information and resources and support, both material and also just human emotional support, as possible. We met with
Yeah, so before we open it up to questions, I just wanted to mention that here is how I can be reached best at Cohio about any of this. If organizations are thinking about intervening in this in a way similar to UACT, how UACT did, I'm always happy to talk about that. So please feel free to reach out to me there anytime. And with that in mind, maybe if folks have questions, would it make most sense to do the hand raise icon? And Elizabeth, would you be able to sort of moderate that?
Yes.
All right.
I think I can get us started. I had a question.
Yeah.
If you're not in the Athens area, how do you find out if your county community has a group similar to UACT? Is there an easy way to find that out?
Well, soon when Cohio launches its new website, that information will be included in our local services finder. Off the top of my head, I can say that organizations that are kind of broadly similar to UACT elsewhere in the state include groups like the Dayton Tenant Union, the Cincinnati Tenant Union. Um, I would include NEOC, the Northeast Ohio Coalition for the Homeless, on that list. I would include the Greater Cincinnati Homeless Coalition. Of course, there are also all of the legal aid organizations that are very much interested in doing work in this area. There are the regional fair housing centers in Ohio. So in the case of Lasco, who I mentioned earlier, they have an in-house fair housing center, but elsewhere around the state, fair housing centers are more often separate entities from the legal aid organizations. And are there any local tenant advocacy groups that folks in the audience know about that I'm leaving out of that list? Well, hopefully there will be more in the future. And I should mention, this is an issue that such groups can form to address. United Athens County Tenants is still a 100% volunteer organization. It was just a group of tenants who decided nobody was coming to save us and we needed to figure out how to do advocacy work. And so, yeah, this is an issue that shows why such groups should exist, and there are a whole lot of other issues too. Um, and I should mention that through Cohio, I'm able to provide informational support to groups who are interested in doing tenant organizing, individuals who are interested in creating new tenant associations. So please feel free to reach out to me about that as well anytime.
Does anyone have any further follow-up questions for Damon? Oh, here's something in the chat.
Okay.
Question is, we live in a rural area where one particular property owner has a lot of low income rentals and will work with people with SUD, criminal evictions, etc. If he, oh, okay. If he was not available to a renter, where would that person go? So I think the question is, perhaps sometimes renters feel like the only option are these landlords who are bad actors, but no one else is willing to have affordable rental units.
Yeah, unfortunately, that is often the case. And like my colleague Catherine was saying, that's exactly who these landlords targeted. Vulnerable, low-income tenants who did not have many options. And they were able to exploit that situation. I mean, according to the allegations, these landlords were very methodical in that sense of, figuring out who they would target. Um, I would just say that someone who's experiencing this should still reach out to local survivor advocates, their local legal aid, um, to see what their options might be. In fact, earlier I mentioned that, these situations can be reported to HUD, to the Ohio Civil Rights Commission, to the Justice Department. But oftentimes it's really best to have a local advocacy organization supporting the tenant who's making the report. And providing that person with advice on, not just how to make the report, but sometimes how to navigate their situation to make sure that they don't become unhoused, unsheltered. So I would just, say that tenants shouldn't assume that they don't have options and that they have to accept this behavior. They should at least reach out to survivor advocates and legal aid to find out what options they might have. And oftentimes, there are specific shelters for folks who are trying to flee sexual abuse that can, get people into emergency shelter, get them rehoused. So I would just say, it's important to reach out to local advocacy organizations. It's important that tenants do that and get a better sense of what their options are. It's still going to be the tenant's decision, but they can make a more informed decision.
Got a couple more questions in the chat. One says, can you talk about what to watch out for when meeting new or unfamiliar landlords? Any questions that we as caseworkers can ask to help protect our clients?
Yeah, so I would say, I mean, and the previous question was about a rural context, and that's immediately what comes to mind here is that one thing tenants should always be a little apprehensive about is month-to-month rental agreements. Those are particularly common in rural areas. And, anytime you're on a month-to-month agreement, the landlord can choose to not renew that agreement with just 30 days notice. So, the reason that a lot of landlords prefer those month-to-month agreements is it just gives them so much more power over the tenant. Say there are conditions issues, well, the tenant, sends the letter saying, here's the problem, and if it's not fixed in 30 days, I might choose to exercise my right under Ohio law to begin escrowing my rent. The landlord can just turn around and give them 30 days to leave. And in a situation like this, it also allows that landlord to exert, a greater threat of unhousing someone if they don't comply with the landlord's demands for sexual favors. So I would just say that in general, tenants who are on month-to-month rental agreements are going to be so much more vulnerable to bad actor landlords, including sexual predator landlords, that's just a huge thing to look out for. Now, again, oftentimes tenants have no better option than to enter into a month-to-month agreement. And oftentimes somebody starts out on a year lease and then it ends up changing to a month-to-month agreement after that initial year-long lease expires at the landlord's discretion. So again, tenants don't have all the options they should, but I would definitely look out for those month-to-month agreements. And I would also just encourage folks to ask around, ask other tenants, whether it's on Reddit where tenants can ask these questions anonymously and get responses from other folks anonymously. But, what is this landlord's reputation? What have you heard about them? Um, yeah, I think, I mean, and I will say that, if anybody asked in a forum like that, what have you heard about Kevin Martin? What have you heard about Joe Lucas? The response would have been, essentially they're sexual predators. I experienced this, my friend experienced this, et cetera, et cetera. So yeah, I would make those two suggestions. And then I see the other question in the chat there. Are there any guardrails against tenants who may be guilty of making sexually inappropriate advances on landlords? So the Fair Housing Act applies to tenants in this situation. It's a protection for tenants. More broadly, it applies to home seekers, homeowners. It is not a protection for landlords. So what protections would landlords have against a tenant who is sexually harassing them? I would not be the expert on that. I would say that they could certainly look to any uh, protections that exist in state law, any criminal law protections. Also, they should look at the Ohio Landlord Tenant Act and specifically subsection 532105 of the Ohio Revised Code, which lays out tenant obligations. Because I would think, and this isn't my area of expertise, but I would think that a tenant sexually harassing a landlord could potentially violate some of those tenant obligations and perhaps even be therefore a lease violation, which would give the landlord certain recourse as well.
Any other questions? We have two related trainings coming up, just as an FYI. On October 30th at 10 o'clock, we are going to have a training about victims of sexual assault and housing. So just generally best practices for individuals who are unhoused or facing housing instability because they've experienced a sexual assault. And then on Thursday, November 13th at 2 o'clock, Damon will be back to do a just a general fair housing training to cover those rules and regulations. So if you're interested in any of those topics, be on the lookout in your email. We'll be sending out training announcements with links. We also, on our website, cohio.org, we do have a training calendar which lists out the trainings that we have planned through the end of the year. So take a look at that. Any last words, Damon?
No, I mean, I just want to thank everyone for attending. I think that, I mentioned that a disproportionate number of those Justice Department lawsuits have occurred in Ohio and particularly in Athens County. I think that speaks to two things. One, the existence of some bad actor landlords, but two, the presence of some committed tenant advocates at Legal Aid, at UACT. And so, I think in that sense, it is a success story